we're muted. And Roy, is he here? Yeah, he's here. Okay, good. He's here. Oh, I can turn his audio off and on too. Good deal. All right, and we've got some attendees, so that's why I wanted to pop it. So the attendees were muted, so we're fine.
Welcome. Thank you all for logging on. We'll begin in just a few minutes. I'm Marjorie Stevens, CEO for BBB serving Northern Indiana, and we welcome you today to our first Lunch and Learn of 2020. Today, we'll hear from a local attorney about legal concerns arising out of the COVID-19 pandemic. The BBB is here to support you through the coronavirus and beyond. It's a new journey for all of us, but we're here for you. Reach out to us and we will do everything we can to assist you. A few housekeeping items. Everyone is on mute. Questions can be submitted anytime throughout the presentation via your chat box. Questions will be answered at the end of the presentation. Following the presentation, your local BBB may have additional resources. Today's content will be presented by Roy Kiplinger of Kiplinger Law in Fort Wayne. Roy is a solo practitioner with a practice concentrating on bankruptcy, creditors' rights, mortgage foreclosure, commercial law, general corporate law, estate planning and probate, and real estate. Roy graduated from the University of Michigan in 1987 with a Bachelor of Arts with high honors in history, followed by earning his law degree from the U of M Law School in 1991. Roy is a member of the Indiana State, the Ohio State, and the Allen County Bar Associations, and serves as a member of the BBB's Board of Directors. Welcome, and thank you for being here today, Roy.
Thank you, Marjorie, and thank you all our attendees for logging in today. Appreciate your being here. We're going to spend a little bit of time today talking about how the pandemic has had some legal effects on business, and in particular, the legal effects on commercial contracts. Now, as you know, the pandemic has had, well, it's really affected everyone, but it's certainly affected businesses from shutdowns to slowdowns and everything in between. And all of that has had an impact as well on the commercial contracts that are a big part of almost every business. As a result of the pandemic, there are a lot of parties to contracts that are finding that they are unable to meet or perform their obligations under the contract. And in fact, the pandemic has created so many underlying changes that sometimes the very subject matter of a commercial contract just isn't even relevant anymore. Given these circumstances, there are a number of legal doctrines that can provide a legally legitimate excuse for non-performance under a commercial contract, or a defense to a breach of contract action. And we're going to talk about 4 of those today. Those are force majeure, impossibility of performance, commercial impracticability, and frustration of purpose. Starting with force majeure, this legal doctrine is a contractual doctrine, meaning that if it's relevant in your particular contract that you're looking at, it will be in that contract, in the language of the contract itself. And force majeure provisions are frequently included in commercial contracts, and often in the sort of standard or miscellaneous provisions that appear towards the end of most contracts. And attorneys in particular often refer to these sections as the boilerplate provisions of a contract, and sometimes they don't always get a lot of thought or attention. But here we are in a situation where one of these miscellaneous provisions in a commercial contract could be very key to any business that's a party to one of these contracts. So let's talk a little bit about what sort of events would trigger the application of a force majeure provision in a contract. Typically, if you look through the commercial contract and you find a force majeure provision, you will see a list of specific events, or sometimes even just a single event, that will trigger the force majeure provision. In other words, if one of those events in the list has occurred, then the force majeure provision can come into play. And those events can range from acts of God, such as tornadoes, floods, those kinds of things, acts of government, war, and also the destruction of the subject matter of the contract. Sometimes the contract will have, in addition to a list of specific events, they'll also have a catch-all clause, which will say something like, or any other event that's reasonably unforeseen by the parties that makes performance impossible. Something along those lines. So if you have a contract with a force majeure provision, you want to look at your list of events, see if, in the current circumstance, see if something along the lines of quarantine, epidemic, pandemic, government shutdown, something like that is included in that list. If not, then you want to see if there's that catch-all clause in there that might be able to bring into play what we're experiencing right now with the pandemic. The next thing that you want to consider with respect to a force majeure provision is what kind of excuse, what kind of relief from performance does the provision provide? It may provide something very specific or limited. It may not excuse total performance, but it may partially excuse performance of the obligations under the contract. Or the excuse may be temporary in the nature of delayed performance rather than permanent, and you don't ever have to perform that particular obligation. The one thing that is almost always true with force majeure provisions is that a payment obligation is almost always not one of the things that is excused. Next, you want to take a look at the timing provisions, if there are any, in the force majeure provision. What sort of notice do you have to provide if you're going to try to activate the force majeure provision? It's usually going to be written notice. And is there a time frame within which you need to make a claim under this force majeure provision? If so, you want to be very careful of complying with that, because otherwise you may well waive the right to use the force majeure provision. And there may be other requirements as well, so you want to pay attention to that. The next legal doctrine that we'll talk about a little bit is impossibility. Impossibility is it's called a common law doctrine, meaning that it's not going to appear in the language, the actual language of the commercial contract, but it's sort of a broader based doctrine that's based on prior opinions of courts and legal practice. One of the key element really of the doctrine of impossibility is that performance must be absolutely impossible. So it can't be that it's because of the pandemic, performing a particular obligation will be very difficult or much more expensive than anticipated. It has to actually be impossible to perform. And the causes of impossibility are really pretty similar to what you might expect to see in a force majeure provision. That would be acts of God, government actions, and also destruction of the subject matter of the contract. For example, number of years ago, any of you out there who are college football fans, you may remember that the College Football Hall of Fame was based in South Bend. And there was the company that was managing the Hall of Fame contracted with a vendor to provide concession services in the Hall of Fame. And all was going fine until somewhat unexpectedly, the College Football Hall of Fame moved from South Bend to Atlanta, Georgia. Now the vendor wanted to continue to honor its contract and get paid, but the management company argued, among other things, that because the Hall of Fame was no longer there in South Bend, it was impossible, the contract was impossible to perform. And ultimately, the management company did prevail. So that gives you an example of what impossibility might entail. Again, and as with force majeure, economic hardship or the inability to meet payment obligations because of the pandemic are not typically going to be sufficient to employ the impossibility, the doctrine of impossibility. The next doctrine that we're going to talk a little bit about is called commercial impracticability. And there's sort of two aspects to this doctrine. One is statutory and one is common law. The statutory element is in the Uniform Commercial Code in Article 2, which deals with the commercial sale of goods. In particular, Section 2-615. And this basically says that an unforeseen event which makes the commercial contract, which makes performance under the commercial contract so impractical that it really undermines the agreement that the parties entered into would qualify for this doctrine of impracticability. Now, remember, if for purposes of the commercial code, Uniform Commercial Code provision, that only relates to the sale of goods. It wouldn't relate, for instance, to a lease or an event contract. Those would not have the Uniform Commercial Code apply to them. But there is also a common law element of this doctrine of impracticability. And it, not surprisingly, is similar to what's in the Uniform Commercial Code, in that generally it's what they're looking at is there an unanticipated circumstance which really changes the nature of what the parties agreed to, or sort of undermines the very heart of the agreement that the parties reached. Now, actual impossibility of performance is not required with commercial impracticability, but you do have to show that performance would be extremely and unreasonably difficult due to an increased expense, injury, or loss. And remember, this aspect of commercial impracticability sort of applies across the board as far as commercial contracts. It's not limited to just the sale of goods, as with the Uniform Commercial Code provision. All right, next is the doctrine that's called frustration of purpose. And this is also a common law doctrine. So it's just found in the opinions of courts and legal practice that's built up over time. And it is similar to the other common law doctrines that we've discussed, in that the intervening event, in this case the pandemic, would have to undermine the primary or main purpose of the commercial contract, and do so in a way that the parties to the contract could not have reasonably foreseen or allocated the risk of to one party or another. And an example of this, a good example, I think, would be going back to the Hall of Fame, Football Hall of Fame case that we discussed earlier. The purpose of that contract was to provide concession services in the South Bend located Hall of Fame. When the Hall of Fame was no longer located in South Bend, there was no reason to have concession services in that particular building. So that would sort of undermine the very purpose for the management company having entered into the agreement in the first place with the vendor, but most likely was not something that was reasonably foreseen by either party. So those are the four doctrines legal doctrines that we're going to talk about. I also wanted to talk briefly about small business bankruptcy, which can also affect, as most of you probably know, the enforcement of contractual obligations. And there have been some pretty dramatic changes in the bankruptcy code recently. Actually, not even caused by the pandemic, but they could play a great role in the aftermath and economic effects of the pandemic. A lot of you are probably familiar with Chapter 11 bankruptcy. That's the kind of bankruptcy that typically is used by businesses, and often very large national businesses that are trying to reorganize. There's a lot of retailers in the last 2 or 3 weeks that have filed Chapter 11 bankruptcy. Hertz Rent-A-Car filed just a few days ago. There's a lot of benefits to Chapter 11, but it's really not very practical for smaller businesses. So last year, in 2019, Congress passed and the president signed the Small Business Reorganization Act of 2019, which basically created a new type of Chapter 11 bankruptcy, which is sort of a hybrid of Chapter 11 that's used by the big businesses and Chapter 13, which is frequently used by individuals or small business owners. The qualification to get in is that the aggregate amount of debt owed by the business or individual filing under this small business reorganization is 2.725 million or less. Now, because of the pandemic, that debt limit has subsequently been increased to 7.5 million, so it makes it more accessible to more small businesses. Some of the key elements of this new small business reorganization is that there's a trustee who is appointed in each and every case, and their job is in large part, not entirely, but in large part, to facilitate successful completion of the bankruptcy by the small business or small business owner. And I mean, this role is somewhat similar to a Chapter 13 bankruptcy trustee. Only the debtor has the ability to file a plan of reorganization in this small business bankruptcy provision. In the larger Chapter 11, any creditor or the unsecured creditors committee, or any creditors committee for that matter, may file a plan of reorganization in the case after the exclusivity period for the debtor to do that has passed. So this is a big protection for debtors in the bankruptcy case, and makes it a little bit easier for them to retain control of how the case progresses. Another key element for small business, this new small business reorganization provision does not require a small business owner to give up their ownership interests in the business, which is something that typically would have to be done in a Chapter 11 that is used by the larger companies. Another element which is really key is if an individual is, business owner, small business owner is using this provision, and prior to the bankruptcy filing, they took out a mortgage loan on their house and used that money to help finance their business, then in the small business bankruptcy, they can modify the terms of that residential mortgage loan, which is something that you cannot do in any other chapter of bankruptcy. So that is potentially very helpful to small business owners. And, as we said just a couple minutes ago, bankruptcy is frequently used by businesses when they're faced with contractual obligations that they cannot meet. So I would expect in the coming months that we're going to see quite a few of these small business bankruptcies. So lastly, let's sort of sum up and see where we are, give you a few recommendations to take away. Certainly, what we're all facing right now is unprecedented, and that in turn creates great uncertainties both in the business world and in the legal world. And all of the things that we've talked about today have not been, from a legal standpoint, have not been greatly tested in the courts, which makes attorneys' jobs difficult because it makes it very hard for us with certainty to advise our clients on what to expect. So be aware if you're faced with one of these situations with a commercial contract and you go to your counsel seeking advice, they may not be able to, with great certainty, tell you what to expect. Certainly, particularly if you think there might be a force majeure provision in your commercial contract, read that contract very carefully. But read it as far as other obligations and time deadlines that might be unrelated to force majeure as well. Certainly, when we're in this kind of situation, it always makes sense to document as thoroughly and fully as you can everything that you do in connection with a commercial contract that you are unable to perform on, or that the other party to the agreement is unable to perform. The more of a record that you have, the more thorough notes, letters, emails, the better that your attorney will be able to assist you, or that you'll be able to work with the court if it comes to that. The other thing that I think, because of the uncertainty, it really gives parties, if they find themselves in a situation where one party just can't perform under the contract, or the contract really doesn't even make sense anymore, at least for one party, is to work together and try to negotiate some sort of modification of the obligations under the agreement that help both parties and make sense for both parties as much as possible. And that could involve delayed performance or reduced performance, or any number of other things. And I guess lastly, I would say, if you are faced with one of these commercial contracts with either you're not being unable to perform or the other party being unable to perform, consulting with counsel to help you work your way through the situation would almost certainly be a good idea. Well, that's the end of the formal presentation. I hope that you've found that helpful. If there are any questions that have come in, I'd be happy to try to answer them.
Okay, we do have one, Roy. If your small business is struggling, at what point do you contact an attorney and pursue reorganization versus just seeking a financial advisor from, and can you suggest any steps there?
Okay. Well, I guess I would say, in my experience, if you are thinking that maybe you need to consider bankruptcy, then it probably would be a good idea to at least talk with an attorney who is familiar with bankruptcy and could help you assess your business's situation and talk with you about the bankruptcy and non-bankruptcy options that are available, and then allow you to make an informed decision about whether bankruptcy does in fact make sense at this point, or if there are other options available, which make more sense. And as things progress and things change, that assessment can change as well. So, but I think that if you are in a position where you think that bankruptcy might be a reasonable option for your business, then you probably reached the point where it's a good idea to talk to someone who can advise you on all of those options, including the bankruptcy ones.
Thank you.
Sure.
Okay. We want to thank everyone for attending our BBB Lunch and Learn. And thank you, Roy, for being here with us. This session
Absolutely, my pleasure.
Thank you. This session was recorded and will be available for viewing next week. So watch our social media, Facebook, Twitter, and LinkedIn for it there. Have a great rest of your day, everyone.